Well, welcome back, Love Nation. This is Nina. Make sure you guys like, share, and subscribe. Thank you to everybody that has been coming to my channel. Like this video, share this video, and hit that notification bell so you guys know when I drop my next one. You guys, we are going to get straight into chapter 9 as a lot of tea is coming out in this document. Justin B's lawyers are not playing around with Blake Lively or Ryan Reynolds. And let's just get straight into chapter 9. Leave your comments below respectfully, and let's go. Alternately, the FAC states a claim for intentional interference with a prospective economic advantage. Per Eschel Pharma, under California law, the elements of intentional interference with at-will contracts are effectively equivalent to intentional interference with prospective economic advantage, which also requires a plaintiff to plead conduct that was wrongful by some legal measure other than the fact of interference itself. The purpose of this requirement was to eliminate claims for interference where a defendant's act was privileged as economically self-interest, competition. Accordingly, the pleading standard is the same for intentional interference with an at-will contract and with prospective economic advantage. As set forth above, the Wayfair parties have pled an intentional interference with contractual relationships claim, even if their contracts with WME were terminable at will, because Blake Lively is at least vicariously liable for defamation, which is an independent wrongful act. However, in the alternative, the Wayfair parties' tortious interference cause of action may be deemed intentional interference with prospective economic advantage, because the relationship with WME probably would have resulted in an economic benefit to the Wayfair parties. To show an economic relationship, the cases generally agree that it must be reasonably probable the prospective economic advantage would have been realized but for defendant's interference. Here, the allegations give rise to an interference that WME was engaged in procuring engagements for the Wayfair parties, which were reasonably probable to benefit them economically, as they had previously done. Indeed, discovery will show that there were specific interested counterparties inquiring with WME to engage the Wayfair parties. Section E. Blake Lively is liable for her direct actions as well as by conspiracy. The Wayfair parties have not brought a standalone claim for civil conspiracy, as conspiracy is instead a legal theory by which parties may be made jointly liable for underlying wrong. Conspiracy is not a cause of action, but a legal doctrine that imposes liability on persons who, although not actually committing a tort themselves, share with the immediate tortfeasors a common plan or design in its perpetration. The burden of proving, let alone pleading, tort liability on a theory of conspiracy is not high. See the court case cited. It is axiomatic that the proof required to show that a defendant knowingly associated with an existing conspiracy need not be overwhelming. Indeed, participation in conspiracy can be shown entirely through circumstantial evidence. The Wayfair parties have pled ample allegations in connection with each cause of action against Blake Lively to support the existence of a conspiracy at the pleading stage. And you guys can pause this right here if you would like to read this cliff note. And let's continue. The FAC alleges that Ryan Reynolds and Blake Lively made a joint threat to attack the Wayfair parties in the press unless they immediately issued a self-emulating press statement. The Wayfair parties have also pleaded facts that establish each claim against Blake Lively based on her own direct acts. Finally, even if there exist technical defects in the conspiracy allegations, the Wayfair party should be granted leave to amend. Where deficiency could feasibly be cured through amendment, the court will dismiss the civil conspiracy claims with leave to amend. Section F. The FAC states a claim for breach or implied covenant of good faith and fair dealing. Blake Lively also argues that the FAC fails to state a claim for breach of the implied covenant of good faith and fair dealing for failure to identify a specific contractual provision that was frustrated. Blake Lively even argues, apparently with a straight face, that she did not fail to cooperate with the Wayfair parties. The Wayfair parties can and will amend to add additional specifics if needed. For example, Blake Lively's contract requires that her right to consult and approve on certain aspects of the film's production and marketing be exercised in a reasonable manner and not so as to frustrate Wayfair's full and timely development, production, and or exploitation of the film, and or to force Wayfair to bear any additional cost with respect to such consultation or approval rights. The contract further specifies that Blake Lively would not have the right to terminate her performance under the contract except in extremely narrow and inapplicable circumstances. Yet, as alleged in the FAC, Blake Lively threatened over and over to terminate her performance of both acting and promotional services. Blake Lively also agreed that she would not do any act that would interfere with complete enjoyment of the rights and privileges granted to Wayfair. Blake Lively claimed that she did not frustrate any specific contractual provision is frivolous, and her motion to dismiss this claim should be denied. G. Even if the motion is granted, fees and damages cannot be awarded. Blake Lively is not entitled to damages or fees for the same reason she cannot prevail on this motion, namely that her motion raises disputed issues of fact that cannot be resolved at the pleading stage. As set forth in greater detail, 3 prerequisites implicate matters of disputed fact and cannot be determined as a matter of law on motion to dismiss, where the court must construe all factual allegations in the complainant as true. Furthermore, Section 47.1 cannot be used as a basis for an award of damages or fees for the same reason that New York's anti-SLAPP statute cannot provide a basis for an award of fees to the other consolidated defendants on their motion to dismiss. Application of the law at the stage of the proceedings would conflict with Rule 11 of Federal Rules of Civil Procedure by imposing a draconian and mandatory sanction where a defamation plaintiff brings a non-frivolous claim that nonetheless does not survive a Rule 12b-6 motion to dismiss. See court case cited. As noted in Brady, Rule 11 permits a court to impose sanctions only after the adverse party has been given notice and a reasonable opportunity to respond and to withdraw or correct the challenged paper. By contrast, California Civil Code 47.1 has no such requirement, and a party may seek sanctions without providing any advance notice to the adverse party. Furthermore, under Rule 11, sanctions are permissive, while under Section 47.1, sanctions are mandatory. Accordingly, Blake Lively cannot be rewarded any damages or fees pursuant to Section 47.1, both because issues of fact preclude any such award and because the statute conflicts with Rule 11. Finally, awarding to Blake Lively Damages under Section 47.1 would violate the United States Constitution because imposing treble damages on unsuccessful defamation plaintiffs would impermissibly burden the exercise of rights protected by the Petition Clause of the First Amendment under the Noor-Pennington Doctrine. The Petition Clause protects the right to the petition the government for a redress of grievances, which the United States Supreme Court has recognized as one of the most precious of the liberties safeguarded by the Bill of Rights. See court case cited. The Noor-Pennington Doctrine arose in the context of antitrust law, in which the United States Supreme Court held that the Sherman Act cannot prohibit activity that constitutes a concerted effort to influence public officials regardless of intent or purpose. The Noor-Pennington Doctrine was subsequently expanded to include the right to petition the courts for redress, as the Supreme Court made explicit that the right to petition extends to all departments of the government and that the right of access to the courts is but one aspect of the right of petition. The Supreme Court has extended Noor-Pennington immunity to preclude liability for bringing a suit that, though based on a genuine grievance, is nevertheless unsuccessful. See court case cited. The Second Circuit applies Noor-Pennington to state law claims. See court case cited. The doctrine now applies broadly to shield defendants from liability for engaging in conduct, including litigation, aiming at influencing the government. See court cases cited. Here, the pursuant of a civil claim against Blake Lively, brought before a federal court, is plainly an exercise of a right protected by the Petition Clause of the First Amendment. To exercise of that right in that imposes draconian, one-sided sanctions on a defamation plaintiff who brings a non-frivolous but unsuccessful suit. And then continuing, it says, notably, Section 47.1 imposes a mandatory award of attorney's fees, costs, and treble damages, as well as potential punitive damages, only against an unsuccessful plaintiff. No similar remedies are available against an unsuccessful defendant. The statute that would award attorney's fees only to prevailing defendant, not prevailing plaintiff. The First Amendment right to petition government for the redress of grievances. Nor is this a case where the wayfarer's parties' claims are baseless, let alone baseless to a point of falling outside of the First Amendment. On the contrary, hundreds of pages of evidence demonstrate that a sound, factual basis underpins the wayfarer's party's claims against Blake Lively, and certainly no one could seriously accuse the wayfarer parties of lacking both an objective grounding in fact and a genuine subjective intent and expectation to prevail, as will be required to bring this case within the sham pleading exception to the Noor-Pennington Doctrine. Accordingly, in a matter of first impression, in any court, it is apparent that the California Civil Code 47.1 impermissibly chills the exercise of the rights guaranteed by the Petition Clause of the First Amendment and certainly cannot be applied to grant Lively an award of fees, costs, damages at this stage or any other. We are going to conclude the reading of Part 9 right there. And then in Part 10, we will move to get into the conclusion of reading this explosive document. I definitely want to know what you guys think below. Share your opinions about this case respectfully. Like, share, subscribe. Until next time, be safe and enjoy your day. Bye, guys.